Many of you may know me from all the emails that you have to suffer, the emails that I have to send out. Anil Kumar. I head the Booth Alumni Club of India. And I'm saying this for the benefit of guests, non-Boothis also tuning in. And it is our privilege to have our guest speaker, Mr. Mohan, give us some guidelines on making a will in India. That's something that that he's been very careful to point out. While the others settle in, sign in, let me, for the benefit of everybody, again introduce Mr. Mohan, even if you've seen the email announcement. He is an independent law practitioner based in Chennai. He has over 2 decades of experience on various aspects of law, including civil and criminal law. And I'm pleased to say that I've known him for way more than 2 decades. I've known him for 35 years. He's been a childhood friend and a trusted sounding board on many aspects of law and business. He practices on both the trial and appellate side in the subordinate courts and also the Madras High Court. He also has experience since 2003 in conducting cases before the Supreme Court of India. He has been a public prosecutor for the CBI as well for over 6 years until 2018. He has a law degree, BL, from Ambedkar Government Law College in Chennai from 1998. Here's how it's going to work. All attendees are on mute so that the discussion can stay focused. You must have questions. Please take the time. You can begin typing your questions in the Q&A window. If you're familiar with Zoom, at the bottom of the screen, you'll see a Q&A panel where you can begin typing your questions. We'll take the questions one by one in the next 20-25 minutes. We'll begin with a short presentation by Mr. Mohan. It's not a slideshow, it's an overview of wills. And when it's time for the Q&A, I'll play the role of question feeder. I'll hand questions to Mr. Mohan in the appropriate sequence. I'll also do this. I will invite you to, whoever has raised a question, I will invite you to unmute yourself so that you'll have the opportunity to provide some additional clarity on your question, and even ask a follow-up question as appropriate. We'll make sure to cover all the questions, and I think we'd all appreciate that Mr. Mohan is happy to stay on for at least 10 minutes beyond 7 o'clock. So it's 6:04. Mohan, shall we get started?
Yeah, sure.
The floor is on yours.
Yeah, thank you, Anil, for the kind words. And hello, everybody. Of course, the reason why we have been impelled to have a discussion on the subject of wills is because of the prevailing pandemic, COVID pandemic conditions, and the resultant deaths that has taken place. The number of deaths, of course, everybody knows. The rate at which the number of deaths owing to COVID has been alarmingly rising over the past at least 2 to 3 months. So my initial thoughts would be that, yes, no doubt COVID has impelled us to have this discussion, but there is no cause for alarm, point number one. The second point is that whenever we go about thinking in terms of a will, it's very important for us to not hurry up and get overwhelmed by the situation that we are faced with, because what we are doing by writing a will or making a will is that we are deciding about the properties that we have acquired over a period of time and which has to be passed on to some other person, maybe the next generation or someone else whom we feel or we hold close to our heart. So it's a very important decision that we are going to take in our life. So this is going to be a perspective with which we'll have to approach the making of a will. Now, coming to the topic as such, that is the making of a will, that's the topic as such. I would like to structure it under 3 basic headings. That is, the first one being, what is a will? Let's understand first what is a will. And the second head under which the discussion should progress is, why and who should make a will. And then the third head under which the discussion should further progress is the structure of a will, or the actual making of a will. So these are the three basic heads under which I would like to make this presentation. And now I would like to once again reiterate that this is going to be a presentation at a very basic level, so that we are not going to touch too much on law. That is why I'm not doing a slideshow or anything for that, because it need not be, or the subject need not be too heavy for you all. All that you need to know is how you need to approach a lawyer to get the will done in the most effective way that you need to do. So with this background, I would like to start. So the first heading under which I would like to start the presentation is, what is a will? So first of all, let us understand the concept. The concept is, all of us, I am sure most of them are in their 30s or maybe around 40, and we would have seen our parents acquiring property, or rather getting property from their grandparents. And we may not have, it would have done, we would not have noticed it. Okay, either it might have come automatically, or it may be through some instrument. So there are two ways by which a property from your previous generation, it can pass on to the present generation. One is by making of an instrument. It's called a testamentary mode of transfer. The testamentary mode of transfer is the will that we are talking about. The other is what is called the laws of succession, which is automatic. That is, nobody writes anything, and the law of the land will take its own course. And when the man or a woman passes away, then the properties that a man or woman are held at the time of the death will be passing on to the next generation or to the designated persons based on the laws of succession. So these are the two basic methods by which properties, when I say properties, it includes both movable as well as immovable properties. Movable properties will include money, gold, stocks, anything that is, of course, you should be able to understand what is movable and immovable. So this is the way the properties will travel from one generation to the other generation. Now, first, the other concept that we need to understand is, there is no rule of nature which says that property of a person will have to automatically go to his son or daughter or wife. There's nothing like that. It's not a rule of nature. So how these laws of succession has taken place? So when we try to think in those lines, then what we will be able to broadly understand is that as we evolved as a society, laws got, of course, before that, the human beings, being social animals, the traits, we have got a unique trait other than the other animals. That is, we acquire property during our lifetime, and we also we are also interested in furthering our own progeny. Okay, so that, which means our own kith and kin, we would like to advance the interests of our own kith and kin. So this, over period of time, over very long years, maybe centuries, what has happened is, has developed into the laws of succession, and it has crystallized into the laws that are there today, which says that a person who has acquired property passes it on to his kith and kin. I will use the word kith and kin carefully, because it's not in all cases where it's only the sons or the daughters or the wife who gets, or the mother who gets a property. So this happens automatically, and that is called the laws of succession. Now, this is one method. Then, as I told you earlier, the other method, where a property of a person who has acquired some amount of wealth travels from him to the to his kith and kin, or to the persons whom he wants to give, is by way of a testament. Testament is a written document, so it's called a testament, and that testament is what we call in common parlance as a will. So that is called testamentary succession. So that is this testamentary succession is what we are interested in at the present. The laws of successions are always there. Why the laws of succession are there is not everybody writes a will. Normally, it's not everybody that you know that writes a will. So what happens if a person dies without writing a will? Somebody has to take his property. So that will be taken care of by the laws of succession that is there applicable in each country. Now, if a person wants to specify that his property is to go to a particular person or group of persons or an institution like that, then the travel of the property that he has acquired has to happen only through what is called as a testament or a will which he writes. So this is the difference between succession intestate, which is without writing a will, and testamentary succession. Now, I would say that not every person needs to write a will. Not every person needs to write a will. Who needs to write a will, first of all, is only a person who has some property to give away, or there is something to succeed. If I don't have any property, if I don't have anything with me, then I do not bother or trouble myself writing any will whatsoever. But if I've got something to give away, or if there is something that might remain after my death, some property, some probably money, or some maybe a property that is an immovable property, maybe a piece of land or a house or whatever, then I can think in terms of writing a will. When, if I want to see to it that the properties that I have acquired are going to be succeeded to or given to persons against the order of succession, the laws of succession. For example, let's say I have a house and I've got 2 sons. My wife is also there. And if I say that one son has already, he has settled himself very well, and the second son is not so affluent, then if I want that son to take my property so that he can support himself after my lifetime, then only if I write an instrument which is called as will that particular property, the only property that I have, will go to that particular son who is not affluent. So this is the basic concept of a will. That is a document that we write so that the properties that we have acquired are traveling to persons after our death in against the laws of succession. Against the laws of succession. Now, under what circumstances, or what are the circumstances that warrants the making of writing of a will? One example I have given you. The other possible, I'll narrate a few examples. For example, now if you take since the discussion is India specific, here if we see either in Christians or among Hindus, the legal heirs, the normal legal heirs are the sons, daughters, the wife, and the mother. These will be the basic legal heirs. Now, suppose you have, let us say, 4 properties, and you have 3 sons and a mother with you. Wife is not there. Let us say, this is an example that I'm giving. This is one of the illustrations. And if you die without writing a will, then there will be a lot of confusion as to who should take what property. Because normally what happens, it will go equally. Then there might be a dispute as to which of the houses, you have left 4 houses, which of the houses should be taken by which of the sons or the wife. So to avoid those kinds of disputes, you normally write a will saying that house A goes to one son, house B goes to the other son, house C goes to the third son, and house C goes to the mother. So this will be one reason why you need to write a will, even though the laws of succession would have taken care of this aspect. This is one. The second aspect is there are certain circumstances where you have certain relatives. Like for example, you have brothers, you may have sisters, and then uncles, aunts, and all those things. So you might be obliged to them for various reasons. Probably in your upbringing, they might have played a very important role, and you would like to support them after your lifetime from the assets that you have acquired. Not necessarily immovable property. You might have some cash, you might have some gold, and all those kind of things. So you would like to gift a portion of that to these kind of people who will not be in the line of succession in the normal course. So how to give to these people? The only way you can give to these people is by way of writing a will, because again I am telling you at the risk of repetition, this is a device for which needs to take effect, or which you desire to take effect after your lifetime. So when you want it to happen after your lifetime, and you want to give it to persons who are not part of the regular succession mode, then you need to do it only through will, by writing a will. So what happens? Suppose, let us say, I have X amount of cash in my account, and let us say I have a sister who is widowed. In the normal line of succession, the widowed sister, my widowed sister, will not succeed to my estate if I don't write a will. If it is going to be what to say, a succession without writing a will, my sister will not get any part of my property, be it cash or whatever kind, or an immovable property. So what happens? As if I want to ensure that some part of it goes to my sister who is a widow or whatever, okay, then I would like to, but I can only do it by way of execution of a will. This is one instance. This is one of the instances. I'll just give you various instances like this is one. The second thing is, lot of people are interested in doing charity. Charity, of course, during your lifetime also you might be interested in doing charity, but there are people who feel that some portion of my acquisitions, my lifetime acquisitions, maybe whether it is money or property, would like to go towards charity. Now, if that also has to happen, then that needs to be done, or that could be done only by executing a will. Only then it is possible. That is one possibility. That is for charity. For charity, if you do, that also requires to be done through the will. Second, now in the present world, what is a marriage is no longer sacrosanct. You have the concept of live-in and various other ways where what is a we have spouses even outside of the institution of marriage. So what happens is, people like people who are living together outside the institution of marriage, because why I say institution of marriage is, marriages are very much covered under the laws of succession, which is called interstate succession. That is, without writing a will itself, institutions of marriage are very well covered. That is, your wife and your children are very much covered even without writing a will. But suppose, let us say, you are in a living relationship, then your child might be able to succeed, but your spouse, maybe the female spouse or the male spouse, may never be able to enjoy the benefits of your acquisition of property. So as a token of love, you might be you definitely might be wanting to give something to your spouse, be it male or female, to pass on to them after your lifetime as a token of love. So if that has to happen, then even then you have to do it only by way of a will. Another mode of another illustration will be, today modern world, law has also recognized the same about living or marriages, gay marriages. Gay marriages are recognized by law, but laws of succession have not recognized gay marriages. Same-sex marriages are recognized today. Even in India, I have the benefit of a judgment from the Madras High Court, where a transgender was allowed to marry another male under the Special Marriage Act. It was done. So a marriage of that nature is possible, but the laws of succession does not support that passing of the property automatically to the such a spouse. So in such a scenario also, you might have to, you will definitely have to write a will if you intend that your, what to say, your lifetime acquisitions also passes on to such persons. This will be another thing. Then certain persons, totally what is unknown persons, they might have supported you at some point of time, then you might be obliged to support it at some point of time, which might have resulted in what to say, your rise in life, your career and life and all that. So you might be uh, say eternally obliged to such person. Then you want to give him or his family some support. Then that is, I'm all talking about this after the lifetime of the person who wants to make the will. Okay, so then if he wants to devise a method of such a nature, even that also can be done only by execution of or preparation of a will. Another example will be under the laws of succession in India, let alone all these things, properties. I've been all along telling about properties to be traveling from the person to someone else. Under the laws of India, you can also appoint a guardian to your son or daughter by way of a will. Suppose you feel, for example, I'll give you some examples. That also I'll give you a couple of illustrations. Let us say I am there, my wife is no more, and my children are very young. Okay, and there is a possibility that after my lifetime, the children may not be what to say, may find it difficult to be supported. That is, support means by way in the aspect of care. So then I can identify the person who can care for my children and designate such a person as the guardian of my children by way of writing a will. So here, this is one unique place where properties don't matter. You are only writing, the only thing that you will write in the will is that my children will be under the charge of so and so till they attain majority. Of course, this what is a guardian, appointment of guardian is only till the attainment of majority by the my children. So this is also one possibility which can be there is a solution by way of writing a will. So these are the various methods by which reasons for which a will can be written. But having said all these things, I will say, if the laws of succession can very well take care of the division of your property and travel of your property from you to the next generation, then you can very well allow the laws of succession to take over and not trouble yourself to write a will. For example, that also I'll just give a small illustration. Let us say you have acquired in your lifetime just one property. Maybe the house that you are living in has been bought by you. You have 3 sons and a wife and a mother, let us say. Then if you write a will, how will you be able to divide this? It'll be very difficult. There's only one house. So let us say it's a flat. It's very difficult to divide it. So if under the normal laws of succession, the children and the wife, that is the person who writes a will, his children and his wife and mother will automatically take equal shares, equal undivided shares in the house. So all of them will be able to live in that property. Now, in such a scenario, one does not need to trouble himself by writing a will and state the obvious. So you need to, that is why I am re-emphasizing the fact that whenever you think in terms of writing a will, please consider the real requirement, whether a will is needed or not. If your intention can be taken care of by the laws of succession automatically, then please don't bother about writing a will. You don't have to trouble yourself by writing a will. But if it is going to be an unequal distribution, or one more scenario I can think of is where the distribution is going to be equal, but the distribution of your assets is going to be in a specific manner. For example, you have a house, you have 2 children and a mother, and as I said, the laws of succession will say equal undivided shares, but you intend to give specific portions. Like, for example, one son gets the ground floor and the other son gets the first floor. Then this particular scenario has to be devised only by method of by execution of a will. This cannot be done under automatic laws of succession, because otherwise the two sons will have equal rights over the ground floor as well as the first floor. So what happens? It might create some confusion. So in such a scenario also, where the property is divisible, the earlier scenario which I told, when it is a single flat where it cannot be divided, then it's better to allow the laws of succession take over. So if you want to give specific shares, and then there is another thing. Let us say you have acquired, say, let's say about 200 grams of jewelry or gold jewelry, or acquired over a period of time you have got acquired. Then these kind of properties also, jewelry. Now you have a daughter and you have a son. Then you would like to give it in a particular fashion. That is, certain set of jewelry you would like to give it to your daughter. Certain set of jewelries you would like to give your son. Then in such a scenario also, because what you want to divide these things by into specific shares. You want to give specific shares to your son and daughter. So in these scenarios also, a will will help you a lot, or help not you a lot, the people who are going to acquire this property through the will, in having a clear idea as to what they are going to take from what you left over or left behind. So these are the scenarios, and during which the wills have to be thought of as a solution to for the properties to travel from you to the next generation. This is one thing. Next, because our audience is such that the audience that I'm addressing presently is such that you are I'm a lot of NRIs are there. Then natural doubt and a couple of questions also I've received. What happens if I'm an NRI, or I've acquired citizenship of different another country, and whether I need to make multiple wills? Now, my straight answer will be that there is no need of making a multiple will. In fact, it is not advisable to make multiple wills. It is always better to write a single will concerning, if you, let us say you have some properties in India and you have some properties in the US, or you have properties only in India and you are an NRI. In all these scenarios, it is always advisable to make a single will, because it will avoid a lot of confusion. If you make multiple wills, then there will be a dispute or confusion regarding which will came first, which will came thereafter, and then if there is an overlap of properties in that, in between one will to the other, then there'll be a lot of confusion, and it will lead to disputes. And the intended legatees, that legatees mean the people who are intended to succeed to your properties after your death, you will be actually directing them to the court to fight it out. So to avoid all this unwanted confusion, it is always advisable to make a single will enumerating all your properties, whether it is in any other country or in India, whatever. So it is always better to have a single will encompassing all your assets, whether movable or immovable. Point number one. Point number two is, the laws of will in India at least does not compulsorily require any registration, which I believe is the case in most of the countries. So there is no difficulty in making a single will. You can use that particular document in all the countries where your interest lies in. That is not you, the persons who are going to succeed based on the will, they can use it in all these countries. Now next, even assuming a registration is done, for example, you have got properties in India and you register a document in India, that is, register the will in India, doesn't matter. The same will can be used if the particular will refers to certain properties outside of India. Then there also this will can be taken and made use of. Only thing is, it will be subject to the laws of that country, laws of succession of that country. That's all. So no difficulty. Making a will, there cannot be any problem. Registering also cannot be any problem. One instrument is more than sufficient. It will take care of all your interests or all the interests of the legatees put together. You can this particular single will can be used in every other country where your property is located, and this document can travel everywhere, and the laws of respective laws of succession in those countries will take care of how the property will have to go to each of the persons. So this is how the last part of my presentation will be regarding the structure of a will. Now, why I'm saying structure of a will is very important is I happen to see a lot of formats on the internet, lot of formats, and I'm not at all happy with the formats that are there, because the structure of the will has to be very simple, point number one. And when a person reads, whether is a person with a legal knowledge or not, whenever a person reads a will, it should be crystal clear what was traveling in the mind of the person who made it and how the properties have been distributed. There should not be any room for doubt. So for that purpose, it is better not to rely on the various formats that are given in the on the internet. It's always better to customize it to your requirement by consulting with your own lawyer and having a discussion. Now, what are the ingredients that are required for a will to be effective, simple, and specific? Now, the basic things are, the first thing that you need to ensure is that you enumerate your legal heirs. That is what I mean by saying who your legal heirs are. In a will, of course, you are going to say who you are, and that will be the initial portion. And the next thing is, it's always advisable for you to specifically mention that you have this many legal heirs. That is, who would have succeeded your properties if the will were not available, if the will was not there. You enumerate that. Then you next enumerate the assets that you have. Or I will even narrow it down slightly by saying that the assets that you are interested in bequesting by way of a will, that should be enumerated. And then the fourth portion should be which are the portions who you are giving to whom. So these are the basic ingredients that you should have in a will in a simple form. So why I am saying the legal heirs should be mentioned in the will is, there should be a clear indication to the person who reads the will that you have written this will out of your own free mind, and also you have considered all aspects before making the will. Because in my experience, most of the wills are subject to challenge. Most of the wills are subject to challenge after the death of the person, by stating that the person who wrote was not in a free state of mind, and he has not been able to apply his mind before writing the will. His state of mind either has been influenced, or he was not in a sound state of mind. This is the basic challenge that happens in every will. So how to, in case I'm saying in the unfortunate event of will being challenged at a later point of time by people who are not happy with the way the properties have been distributed, the one singular thing that needs to be proved in court is that the person who wrote it was of a sound and free mind. So when you enumerate these things, that will be one of the basic indexes to show that you have really applied your mind in deciding how your properties have to be distributed. So this is very, very important, because otherwise the very object of writing this will and putting the directions that this should go this way and all those things will be lost, because all these properties will be mired in litigation in deciding whether the will is a valid will or not. So this is point number one. The next thing is, as far as possible, I will say as far as possible, avoid contingencies in the will. That is conditions. Don't put conditions saying that only if this happens, this particular person will get it. So that should not, you try to, as far as possible, try to give properties clearly, saying that, yes, this goes to so and so person, this goes to so and so person. So as far as possible, if add contingencies only if it is a real necessity. For example, I can just illustrate when contingency can be given. For example, you want to give away certain portion of assets for some let us say for a charitable purpose. Then you can create what is called as a trust itself using a will. A will can be an initial or what is a base document for creation of a trust, where you can say that my property, this portion of the property has to be used as what is kept in trust, and the proceeds from that to be used for this charitable purpose. Then that is a contingency. So under these kind of limited scenarios only, you please use contingencies. Otherwise, avoid contingencies. Give directly, straight away. This is what it is. This is what it is. I'm giving. Next, when you are giving properties to people who are not your natural legal heirs, then kindly, as far as possible, that is, I'm asking you to give a big explanation. As far as possible, give a reasonable brief note as to why you are giving a person who is not your natural legal heir. For example, I told you, my widowed sister, I'm giving. You please add one line saying that she is my widowed sister. So I would like to support her because she's not, she's unable to support her. One or two lines, because these one or two lines may appear very insignificant now, but it goes a long way in establishing the fact that this will was written with clear and sound mind and after consideration of all circumstances. So always when you are giving properties to persons who are not your natural legal heirs, it is better to add one or two lines to give an explanation as to or give an indication of the mind that you have regarding why you are giving to these people. So this will be the basic structure of the will. Next, witnesses. Very, 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 very important. Many people miss it out because registration is not compulsory. Many people tend to not register the will. So whether you register or you not register, the laws of India warrants the the execution of the will be witnessed by two witnesses, irrespective of which religion you are. Mohammedan law is slightly different. That will be a big discussion in itself. Let's not tread into that. But otherwise, other laws, let's say Hindu or Christian or others, the will requires, the law requires that two witnesses will have to attest the will. So my suggestion will be that two witnesses who are responsible, please kindly bear this in mind, that the witnesses are going to sign in the will have to be two responsible persons, because after your lifetime, those are the people who are going to testify that you have been in a sound state of mind when you executed the will. Of course, they need not be worried about the contents of the will. They will not be. So they will not be called upon to ask the justification for the will as such. But what will be called upon when these two witnesses are going to come into the box is that whether this person was of a sound state of mind and whether he actually signed in the presence of these two people. So you have to have two responsible persons, and two witnesses are a must. Even for modifications. There is something called, you see, what happens is, of course, which I didn't, I'll touch on that also now. A will can always be modified, revoked, and all those things. Okay. Now, when a will is written, a revocation or a modification also has to be by way of a written document. Now, that also is in the character of a will, where you require two witnesses to sign a revocation also or a modification also. So all these things, when it is taken up for challenge, I mean, if it is subject to any challenge before a court of law, then what is first looked into is whether two witnesses have signed, because the legal requirement is that if two witnesses have not signed, then this will is not a valid will for any legal purposes. It will be of no use. So two witnesses first. Then next thing is two responsible. Not only should you have two witnesses, there should be two responsible witnesses, because tomorrow they have to cogently answer any question if the will is a subject of a challenge later on by any disgruntled legatee. So these are the basic structure of the will, and of course registration. Yes, I've already told you it is not compulsory, but I will always highly recommend that registration is done so that the regarding the genuineness and the soundness of the mind is very well taken care of by the process of registration, because you are actually going to the registrar office. So that will be another indicator regarding the soundness of your mind. So these are the basic aspects of will, and I think now I will take questions, Anil.
Let me start with this. And
Yeah.
Satya, this is your question. I'm going to invite you to unmute yourself so that you can make any clarifications as you see fit. So the question I'll read out, Mohan, has to do with witnesses. In Satya's past experience, the registered will was disputed. The will's beneficiary, her daughter, was forced by the court to prove that the signature of the will's creator, the father, was genuine, even though the will was registered. The plaintiff disputing the will was the son. Witnesses used in the will had died by then. What could the father, or what should the father have done differently? And what's the value of registering a will? And Satya, if you can speak, if you'd like to speak, you should have the option now.
I'll let him answer, and if he has any clarifications that he needs,
I'll
I
tell
can
you.
provide.
Now in your case, both the witnesses have died. What to say? Even before the will came into effect. That's your case, right?
Yes.
Yes. And the son subjects the will to challenge, because the will has been as per the will, the daughter gets the property, right?
Yes.
Correct. Now here, law very well provides for a will being proved even in the absence of two, that is even in the non-availability of the two witnesses. I will not use the word absence. The will has to be, because for a will to be valid, there should be execution of the will, or sorry, attestation of the will by two witnesses. That is a given. There cannot be any two ways about it. But naturally, it's always possible that the two witnesses could have predeceased the actual maker of the will, or whom we call the testator of the will. So in such a scenario, what the court will require is or what the person who wants to prove the will can prove to the court is that these two witnesses, in fact, witness the execution of the will. For that, the first thing that you need to do is you have to prove the death of these two witnesses. That is the basic, because your case is that you are saying that two witnesses, they are dead. If you are saying that the witnesses are not available and that they are dead, then the first step is you have to prove that these two people, the two witnesses are dead. Once you have proved that, then what you need to prove is the signature, because that is also the subject of challenge, because the son probably has taken advantage of the fact that these two witnesses have died. Then in this scenario, the law permits the signature of the will being proved through other documents. For example, I will tell that is, your father's the testator's signatures might be available in various contemporaneous documents. Like, for example, he might have purchased some property, or his passbook, or let us say if he's working now, then his his service book in government service. There's something called a service book. He would have signed various documents at various levels. At various stages. These documents can be filed in court to and the court can be asked to compare the signatures in those particular those kind of documents with the signature appearing on the will. And if the court is satisfied that the signature found on the will matches with the admitted documents, or the documents which are, yes, correct, it's called admitted documents, those documents earlier, the contemporaneous admitted documents, then there cannot be any difficulty for the court to hold that the will is genuine. So this is how you have to go about trying to prove the will in the absence, or not the absence, in the in the scenario where the two witnesses are not available due to death or for any other reason. For example, not only that they need to be that they need to have died. For example, let us say you are in India and the witnesses have gone and settled abroad for good. Let us say they are in the US. So it is not at all possible for you to bring those witnesses. Then these are the circumstances you need to prove that they have settled down in USA. Like that you have to prove. If you have proved that, then this opportunity of proving it by way of contemporaneous documents will be permitted by court, and the court will not have any difficulty in holding that the will is genuine, and the consequence of the will happen. Yes.
Yeah,
So
that's the. Sorry, Anil, can I?
Yeah, please go ahead, Satya. Yeah, please go ahead.
Yeah, tell me.
That is what you painted as a scenario is exactly what happened, except that the process never came to a close. So the two lessons I've learned out of this is to find the youngest possible witnesses to sign a will.
Yeah, of course, youngest possible witnesses. But see, that's what vagaries of life are. You can never say that we leave this world in any particular order.
Thank you.
Yeah, so law is provided for it. Don't worry. Yeah.
While we have Satya on the line, let me raise a question that he had brought up and Ravi had also brought up. Ravi, I'm inviting you also to come off mute. It has to do with changes. If I continue to acquire assets, will I have to modify a will for each newly acquired asset? Or can I write a will where I simply state that any remaining assets will be split between named parties?
Yes.
A variation of this question from Ravi is, what happens to assets acquired after a will is done? Suppose the will stipulates that assets have to be divided in a particular way between family members, and then you acquire new properties which are not covered in the will, and the person dies before adding that property to the will.
Yeah. Now, always there is one thing that that should also be taken note of. When you write a will, it's always better that you at the end of the will you put one clause, what is called as a residual clause. Residual clause means a clause which will say that any properties acquired by me after the making the will will go in a particular way. That is one way of doing it. But you may after writing the will, and you're still, of course, you are expected to live on for a long time, and you acquire properties, and then you would like to give those properties also in a particular way, that is in a specific way, then it will be highly advisable that you revoke this will and write a new will. And revocation can be done in the new will itself. One line need to be added that my earlier will is hereby revoked. That's always standard. Always a clause is written that all my earlier wills are hereby revoked. So you revoke a will and you can create make a new will if you have acquired properties after making of a will, and you want to specifically assign these properties also, or distribute these properties also in a particular way. Otherwise, residual clause will always do. That will take care of the residual properties. Hello?
Satya, Ravi, any follow-up questions before I move on to the next one?
I'm good.
Yeah, thanks, Mr. Mohan. The question is more on, okay, what if I didn't know that I have an asset coming? Let's say there's an interest or a dividend, or there is a property that I didn't even know that it's going to come. Will that residual clause will cover all the?
Yeah, that's what I said. That's what I said. The residual clause will take care of a speculative acquisition. See, that's exactly my point. That is, you are not aware that something is coming. Okay. So for that, you can always put a residual clause that if I get something, let us say I win a lottery tomorrow. Okay. That is something which I cannot predict, is it not? Okay.
Right.
So you can always designate in the will that you're making that the residual clause will go to my youngest son or my wife, or the residual whatever property that comes after the making of this will can be distributed equally among all my legal heirs. Like that also can be said.
Thank you, Mr. Mohan.
Yeah.
Sorry, my audio has.
No, you're audible. You're audible, Anil.
Anil, I am done with the question. If you're waiting for me.
Yeah.
Okay. Looks like Anil's audio is gone, so he's typing the question.
He's typing the question.
Can you hear me now, Mohan?
Yeah, I can hear you, Anil. I can hear you, Anil. Only if you speak, I'll be able to hear you. You're not speaking.
Sorry about this, folks.
Yeah.
Looks like Anil's audio is still not available. Let me read.
No, you can. What you can do is, Anil, you can unmute the person who wants to ask the question. Then that person can directly ask me the question. Should not be a problem.
Okay, Ankur.
I think CK can do it. If CK is available, CK can also do that. He is a panelist, no? Yeah, I see one person, Ankur Gula. He can be unmuted. He can ask the question directly if Anil's audio is failing.
Yeah, Mohan.
Yeah. Tell me, Ankur. Yeah.
Mohan,
tell me, Ankur. I'm hearing you.
I believe, as per the succession laws, there is something called tier 1, tier 2 in the hierarchy.
Correct.
Laws. Can you talk briefly about that?
See, the laws of succession is a big subject in itself. But okay, I'll just give you a one-liner. We'll see what happens is your class. Of course, I'm sure you're asking about the laws of succession pertaining to Hindus, right?
That's right.
Yeah, Hindus. Yes. See, Hindus, what happens? You will have what is called as class 1 heirs, class 2 heirs, then like that it goes on. Okay. The class 1 heirs will consist of the children, that is sons or daughters, the wife, the mother and father. Okay. And also the son's son, that is if you got a predeceased son, like that, it's pretty complicated. Like, you got a lot of things that will be a subject in itself. So this will be the class 1 heirs. Okay. So what happens if you don't make a will? If you don't make a will, the property will go in equal shares to all the class 1 heirs. Okay. If you, the same way, suppose there are no class 1 heirs surviving. Let us say you don't have any class 1 heirs who are surviving. Then what happens? It will go to the class 2 heirs. All this happens in case you don't write a will. But if you write a will, you don't have to bother about the class 1 and class 2 heirs. There is no problem at all, because you are going to write no, like you can write to any person who you feel is appropriate.
Okay, yeah, got it. Yeah.
Vijay.
Yeah, this is Vijay. My question is, what are the situations in which people normally rewrite or modify wills? And you said no, you should not have conditional. That makes it confusing.
No. Yeah, I'll clarify. I never said that not be conditions, but as far as possible, it is better to avoid conditional will.
Yeah, I agree. That's what I meant.
So you can always put conditions, because I'll give you an example. Okay, let us say you have an unmarried daughter and you have sons who are well settled. When you write a will, you can always say my sons will succeed to XYZ property only if they contribute substantially to the marriage of the daughter. That's one condition. Yes, that can be put. I'm not saying it cannot be put, but only thing is, don't put conditions which cannot be executed, because that will become the subject matter of challenge. That's all.
Okay, so can a condition be put that the share changes after somebody becomes a major, something like that? Is that normal? That's what I'm asking. What kind of situations?
No, please, can you be more specific?
So let's say there is a minor, okay? Because the person is a minor, you want to give certain share X. And once the person becomes a major, you want to give a share Y, whatever.
Oh, yes.
Right?
Yes. So, let's say when the person is a minor, you can say this is going to be X share. And if he's going to become major, then the share changes. Yes, you can do that. Yes, those things can be done.
Okay, that does not require rewriting, I presume. You can just put it in the will.
No. That's what. See, whatever condition you want to, whatever contingency that you think should happen, should be written in the original will itself.
Okay, thank you.
The question was whether male children and female children succeed equally.
That's right. Do they have the same rights, or are there variations?
Okay, so and now I'll tell that. See, yes, male children and female children succeed equally in the absence of a will under the Hindu law. Now, that is from 1989 onwards. Okay, but when you're writing a will, you don't have to have any worries about all these things, because it is going to be in the way you want to give your children. So how it is going to be, how the succession is going to operate without a will, that need not be the botheration of a person who is going to write a will. Yeah,
and let me, Sangeeta, let me invite you to talk. You have the option as well. Go ahead, Sangeeta, if you'd like to clarify.
No, I think I'd like to understand the process, and also my understanding is that it really delays the execution of the will. So is it just faster to write a will? Will the banks and all release all the and the property get transferred faster if you don't register it, or will it get transferred? What's the advantage of going through the process?
No. See, as far as the advantage of going, see, that's what I said. If the property, or if let us say your bank deposits have to go to a person who is not in the order of succession, then obviously you'll have to write a will. Otherwise, the bank will not give those deposits to a person who is not in the order of succession. For example, you might have a sister, you might have children and a husband. Okay, so if you don't write a will, of course your husband will not succeed. Oh no, your husband will definitely succeed. I'm sorry.
Obviously.
Your husband and your children will succeed to the property. But if you wanted to your sister to also get a share of the deposits, the only method by which you can ensure that your sister also gets a share is only by writing a will.
Right, but do I have to probate it and register it?
Probate, yeah. Now, okay, yeah. Good, you brought this topic up. See, probate is a process which is a must pertaining to properties which are situated in the cities of Chennai, Mumbai, and Calcutta. Okay, it's an archaic process. So only if the will concerns properties in Chennai, Mumbai, and Calcutta, then there is a process called probate. In very simple terms, I'll tell what probate is. Probate is nothing but the certification by the High Court saying that yes, this will is in fact the will of the person who died. Okay, they will give a certification. That is all. It can either be a contested probate or it can be an uncontested probate. So that is all. So it's a mere certification by the court saying that yes, this is in fact the will of so and so person. So it doesn't really need to worry. This need not worry other people or other people who have properties outside of these three cities.
But what is the difference between registration and probate, and what is in
three cities? No, correct. See, registration is a process which is done at the time of execution. That is when the person makes a will. Then and there, when the person is alive, he makes the registration. Okay. Now, what happens? Probate is the validation of the will after the death of the person. So that is done by the persons who are going to succeed. That is, the people who have succeeded to the property through the will file it in the court asking for validation. So probate happens after the death of the testator. Registration happens at the time of execution of the testator. That is the essential difference.
So I guess my question really is, if I'm making a will and assuming I'm doing either, getting somebody out of succession into the will or doing asymmetric distribution. What is the advantage of registering and probating a will as opposed to just writing a will?
No, probate. That's what I think you should take the probate aspect out of your head, because unless you say that you have got properties in these three cities.
Okay. Then I don't need to worry about probate.
Yeah, then you don't have to worry about probate. So let's forget about probate. Registration will lend additional authenticity to the will, saying that the person you made, that is, if you are making the will, that you have made it with a free and sound mind.
Okay.
So that
and does it help if the will gets contested?
No, I'll tell you how it helps. See, when it's going to be an asymmetric distribution, people who have got lesser and who feel that they deserve more are likely to go to court. I'm not saying not always, but they are likely to go to court. Okay, when they go to court, registration will lend more authenticity, and the court will be able to decide more easily that this will is an authentic will. That is why.
Okay.
That is where the advantage. There is absolutely no necessity that you need to register a will, but it's always better.
Okay. And how simple is the process? How easy is it to do? I mean, how much time are we looking at?
That's what I can only give the Chennai experience. Now in Chennai, the registration process is completely online. Okay. But I will always advise you to take the assistance of a lawyer, so that he drafts the will in a particular, in the way that I just now suggested, in a very cogent manner, in a simple manner, point number one. And the registration process also, he will be able to guide you and he will be accompanying you, so that the registration process does not become a harassment in itself.
Okay. And then when
and it's pretty easy, and it's see, the cost of registration is very negligible. Don't worry about that. The lawyer fee, of course, the lawyer will decide.
I'm trying to understand the process and how much of a challenge does it create after.
the process of registration is just like any other registration. Have you sold or bought a property?
It's a very
I'm sure you would have
painful
done.
process. One day.
Correct. Okay, the same painful process will have to be undergone for the registration also, but it'll be slightly easier because there what happens, a lot of money is involved. That is, you give or take a lot of money. Here, what happens? This is a registration of a document which is going to talk about giving away property after your death.
Yeah, no one is more thinking about what happens after your death and how to make it easy for that person. That's the thought in the mind.
That is why I said registration is better, because otherwise they'll end up fighting endlessly. Yeah.
Okay. If it's registered, then it will be executed.
The fight, the fight will be, the intensity of the fight will be lesser. I'm not saying that you can avoid all fight. Yeah, because see, if a person has decided to fight, nobody can stop. No,
but the person gets it and then the fight happens, so that he doesn't get it.
No. Once a fight happens, then he gets it only at the end of the fight.
Oh, okay. All right.
Obviously. Yeah.
Okay.
Shall I move on to the next question?
Yes. Thank you.
Sure. This has to do with kinds of assets that can be willed. Let me club two questions. Nishant has asked whether agricultural land can be willed to a foreign passport holder to an OCI holding, NRI. Let me see whether Nishant is still on the session. I don't see Nishant in the attendees list. The related question came via email.
Yeah.
How do we take care of or distribute immovable assets like land, gold, equity?
See, distribution is completely left to the discretion of the maker of the will. Okay, there are no legal rules. Okay, that is the discretion of the person who is making the will. Of course, the lawyer can guide you, saying that how it can be done. There's some level of guidance, but we cannot do. See, the simple answer is whose will is it? It is the will of the person who is owning those properties, right? So it cannot be the lawyer's will. Okay, if you're going to say that the lawyer is going to decide how the client's property is going to be distributed, then it is not the will of the client, right? So how a property is to be distributed has to be decided by the person who is making the will himself.
I think
only thing
the
lawyer can guide him. The lawyer can guide him, saying that, see, I'll tell you how he can guide. See, for example, let us say he has got two properties of unequal value, okay, and he wants to give it between among two sons, okay. Then the lawyer might guide you by saying that, okay, then you can tell one son to pay off, say, about X amount of money to the other person in lieu of him being given the bigger house, something like that. So these kind of advices can be given by the lawyer, okay. But ultimately, who has to be given the bigger house? Who has to be given the smaller house? How much money has to be given to the son who is taking the smaller house? All has to be decided, are all in the hands of the maker of the will. If this is to be decided by the lawyer, then it is not the will of the person who is making it, and that will be the principal subject of challenge in the court.
I think I can understand where this question came from.
Yeah.
Even if someone decides that the person who has the asset wants to give it away, foreign passport holders, OCI holders, cannot own agricultural land in India. I think that's where it comes from.
Yeah, I don't think that is a difficulty. See, that's what I understand that also. See, that is whether agricultural lands can be given to a person of Indian origin who is an OCI card holder, right?
That's right.
Yeah, I don't think there is any bar in that. There is no bar in property being held. Agricultural property being held by person of Indian origin. Not a foreigner, person of Indian origin. Person of Indian origin. I'll reiterate that.
Okay.
You cannot give it to a foreign.
Nishant is not online for any clarifications or follow-up. I'll go on to the next question.
Fine. Yeah.
Can anonymous question? Can immovable properties or financial assets be willed into a trust on one's death?
On one's death, yes, absolutely. A trust can be for even though I will not strictly recommend this process. A trust can be created by way of a will. That is, if let us say I have a property, income generating property, I mean, let's say I have a let's say I own a shopping complex. Let us say I own a shopping complex, okay, and I have got rental income from that shopping complex. I can always write in the will that this property, I can create a trust saying that my brother, my uncle, and my cousin will be the trustees of this property, and the income from this property shall be defrayed to the benefit of my children. That can always, that's a basic concept of trust. So this can be done, no doubt about that. A trust can be created by way of a will, but only difficulty that why I don't recommend this is legally it is possible, it is not a problem at all, but normally why I don't recommend this is because in the in the unlikely event of the property requiring to be sold, the property itself, the property which is created in trust, if you want to sell it for the benefit of the minors itself, or sorry, for the benefit of the children itself, then there is a tedious process of going to court and taking permission and then selling and all those things. Okay, so if you trust your own people, there is no need to create a trust. A trust need to be created only when there is distrust of your own people.
This is a related question.
Legally possible. So my straight answer will be legally creation of a trust through will is possible. Yeah.
Two related questions.
Yeah.
On trust, one is about the advantages and disadvantages of setting up a trust, and another one, and a related one. Let me read out as I see it typed.
Yeah.
Creation of trusts for children with disabilities that may need to be administered by someone other than the beneficiary.
Correct. Now this will be, yeah, now I'll answer this specifically. I'll answer this. See, this will be a good reason for creation of a trust through will, because what happens is children with disability, okay, and the will. Now I will speak about this with specific reference to Hindus, because under the Hindu law, the natural guardians of the children of a child or a minor are the father as well as the mother. So in the absence of the mother, and the father wants to wants to make a will, then I will suggest that yes, he can, because there is no mother, he can create a trust, because the children are with disabilities. So no, but it will not serve the purpose if the properties are directly given to the disabled children who can't handle these properties, and there's every likelihood that the properties might be misused or sold away by people who are having bad designs. So in such a scenario, it is better to create a trust and put your own trusted people who as trustees, so that the income that is generated out of the properties is defrayed for the benefit of the disabled children. Yes, this is one good scenario where a trust can be created.
Let me ask you a question, and Salil, I want to invite you to talk to clarify on your question. I've invited you to unmute yourself. The question that came in the registration form is how best to address a will, not knowing if the primary home for kids will be US or India.
See, if I've understood it correctly, what is the address that needs to be put of the person who is making the will, one, and also to the persons to whom the benefit goes, correct? If I've understood it rightly, that's what it is. They want to find out what is the address that I need to give in the will of either the person who's making the will or the legatee. Legatee is the beneficiary of the will. Okay. It doesn't matter. Okay. Let us say today the persons who are going to benefit from the will are residing in India. And after the making of the will, they happen to go and settle in the US or Hong Kong or UAE, wherever it is. It doesn't, the address of the beneficiary or the address of the person who is making the will simply doesn't matter, because what matters is the properties that are going to be distributed. He can always come and enforce the will at the place where the property is available. No problem. The will, the object of the or the bequest in the will can very well be executed, or what to say, can be enforced in the place where the properties are available. So the address of the person is of no consequence in the making of the will. You can travel all over the world, you can settle wherever you want. It will not matter. Don't worry about that. So ideally, what I would say is, at the time of making the will, you please give the address at that time where they are. The time you can give the address where they are residing. So it will not make any difference. Don't worry.
How should a will take care of the stocks if you are a majority shareholder of the company? I don't know whether Suhas is still online or whether he's in the session that came online at all. What he had in mind. You're welcome to answer it the way you interpret it. How to take care of how would the will to take care of stocks?
It will go back to my earlier. See, again, it will go back to my earlier answer that how you are going to distribute your assets, whether it is stocks or any other thing, or your immovable property or gold or deposits, is in the hand. The decision of how it is going to be distributed is in the hands of the testator. So this cannot be answered unless there is a specific scenario that is given to me. Okay. In general, this can only be answered this way. The person who makes the will decides how the stock has to be different, or how the stocks will have to be distributed.
Okay. Last question, if there's no other question that comes in.
Yeah.
What happens in a situation, for example, in a bank account or a property, the registered nominee is different from the person defined in the will?
Very pertinent question. Very pertinent question. Many
or will
people
it be as per the or will it be as per the natural laws of succession?
See, there is a vast difference between a nominee and a legatee. Legatee means beneficiary under the will. See, under no circumstance a nominee succeeds to the bank account or any bank account or stocks or whatever of the person who is making the will, or who holds the bank account. And nominee, I'll tell you who the nominee is, because a lot of confusion happens. Many people are under the mistaken impression that if they nominate a person in their bank account, that person will automatically get the deposits or the amount that is there in the deposit in the bank automatically. No, that is not the case. Nomination is only for the benefit of the bank. It is not for the benefit of the nominee. The law of nomination is very simple. I mean, I'll just say that. See, when a person dies, it is very difficult for the bank to go behind and make a big inquiry and find out who the legal heirs or who are going to succeed to the deposits by themselves. So that is why they encourage the people who are having deposits in bank to give the name of a nominee, because what happens is banks will simply then call that nominee and take whatever undertakings that they want. They will take various indemnities and hand over the deposit to that nominee. Now, that by no stretch of imagination means that the nominee who received the money from the bank can use it for himself. No, he is having a duty to distribute it evenly or as per law to the legal heirs of the person or the deceased in whose name the bank account stands. If he has written a will, then it is his duty to give it to the person who is named in the will to have succeeded to that particular deposit. So nominee by no stretch of imagination is a person who can succeed to the deposits automatically. So make no mistake that if you are being nominated by your father in the bank as a nominee for his account, you don't automatically succeed to his deposits. If you have got brothers and if you have got your mother, all will get evenly if he is not written a will, or if he written a will giving this particular deposit to a brother, you will only be receiving the money and handing it over to your brother. Simple.
Any follow-up, Ankur?
No, that's very clear and very helpful. Thank you very much, Anil and Mohan.
Yeah.
It's all Mohan. Mohan, you've been very generous with your time. Would you be willing to take one more?
Yes, absolutely.
So his question is,
yeah,
distribution requires a sale of the asset to realize the benefit. What if one of the beneficiaries of immovable property doesn't want to sell?
Let us say, as I told earlier, let us say there is only one property that is available. Okay, one flat, and the father writes it saying that all take equally. Let us say, okay, or let us say he says 3/4 of the share goes to one son and 1/4 of the share goes to the daughter. Let us say he's got two. Let's say the father has got two children and his wife has already died. So that means he is survived by one son and one daughter, and he writes it in this kind of unequal proportion. Okay, that is 3/4 and 1/4. Then what happens is, in such a scenario, then what happens is the obvious way of method of dividing this property is only by selling and realizing the proceeds, is it not? Hello.
Yeah.
So
go ahead,
the only property that you have, if it is going to be given in undivided shares, you can always see, you can use the will and sell it. See, the will can be shown and you can sell it, and based on the share given in the will, that is share designated in the will, that is 3/4 and 1/4, the sale proceed can be divided. No difficulty at all. No difficulty.
Suresh, would you like to follow up?
Yeah, I unmuted myself.
Yes, Suresh.
Thanks, Mohan.
Yeah.
The quick follow-up on this is that what if one of the beneficiary doesn't want to sell it? Can it still be sold?
If the beneficiary does not want to sell it,
if one of the beneficiaries.
I understand. I'll answer that question. See, if the beneficiary, the beneficiary does not want to sell it, then obviously you'll have to file a partition suit, okay, and enforce the sale there.
All right. So it would going to be a difficult, complicated process thereafter.
Yeah. Because see, one person is playing truant now. See, because the reason why I'm saying is that the person who gave the property has given in undivided shares. No.
Even if it was a equally divided shares of an immovable property, but the benefit can still be only drawn after it is getting sold.
No, that's what. If it is clearly divided, then you see, if it is clearly divided, then where is the difficulty in one person selling the divided share? See, difficulty in selling will come only when there is an undivided interest. If there is a proper division, where is the question of? I can't visualize a scenario. If you give me a scenario, then I'll give you an answer.
Leave it for now. It could be probably a hypothetical situation, so we can drop this for now.
Correct. Okay, fine.
I think that's about all the questions that we have. Sangeeta, I messaged you asking whether you had an unanswered question about the process for using a foreign will in India. And Mohan, you may have addressed it when my audio flaked out.
Yeah,
you think it was sufficiently answered?
No, could you please repeat the question?
Sangeeta would like to understand the process for using a foreign will in India.
See, that's what. See, let us get it out of our system that there is nothing called a foreign will and an Indian will. There is only will. There is nothing called a foreign will and Indian will. Okay. Just because you executed it, or the person who made the will happened to reside in a foreign country, it doesn't make the will a foreign will. Okay. So if there is a foreign, going by that nomenclature itself, if there is a foreign will, you bring the will here. If it concerns a property in India, you enforce those to that extent. You enforce the will in India. If there are properties enumerated in the United States, then you enforce to that extent in the United States using the laws of succession in the United States. So there is nothing called a foreign will. There is only a will. That's all.
So you don't have to do anything. I mean, it's a very simple process. Just show a copy of the will to whoever, like the registration of plot or anything.
That's right. See, you produce it in multiple places. That's all. You see, as regards the properties that are mentioned in the will, which are in India, you produce it to the authorities in India and get your will enforced. As regards the properties mentioned in the US,
they won't ask for any additional documentation. That is considered a good enough document.
No, that is what. As I told you, in India, the requirement of 2 witnesses is a must.
Sure, that's a requirement in other countries.
Yeah, suppose let us say the laws of America does not require two witnesses. Let us say, hypothetically speaking, okay. So if you make the will, with the attestation of only one single witness, then the will may not be accepted in India.
So as long as there are 2 witnesses, it's just a photocopy, attested photocopy.
In India, it is acceptable. Yeah, in India, it's acceptable.
Okay,
thank you.
Thank you. Thank you for being. No, I think it's about, we covered all the questions. Thanks for being generous with your time.
Yeah, I would like to conclude with one short point. Okay. Last but not the least, when you make a will, ensure that somebody knows that you have made a will. Okay, and somebody knows that where you have kept the will also. Otherwise, the entire purpose will be defeated.
Thank you, Mohan.
And that is where the registration is important.
Folks, before we all sign off, please take a minute to provide some feedback on the session, on the topic, on how long it was, or to what extent your questions were answered.
One question I saw: do we need stamp paper for a will? One unanswered question was there. Shall I answer that?
Please.
Okay. In India, there is no stamp paper required. You can write the will on plain paper. There is no stamping as far as India is concerned.
I see the question.
It was a question by Sandeep. It was a question by Sandeep Ganesh.
Sandeep, would you like to ask a follow-up?
No, thank you. That was clear enough. Thank you.
Okay. Mohan, it's approaching 7:30, and I also want to be sensitive to folks, if you're not aware, to staff of the Booth Alumni Relations Office who are up at this hour in Hong Kong facilitating the session. Thank you, CK. Thank you, Lenora, for setting this up. Thank you, Mohan, for coming and sharing your knowledge with the attendees. And we hope
thank you for giving me the opportunity. Yeah.
And we hope to bring more such sessions to our alumni club community in India and overseas. Thank you all. If you have any questions, you know how to email us at the club. Have a nice night all. Thank you again, Mohan.
Yeah. Bye-bye. Bye.
Bye.